Yeah.
Okay.
Okay.
Hit start.
Hi, good afternoon. I'm attorney Greg Ippolito with Gehi and Associates. This week on Green Card with Gehi or Green Card with Greg, we'll be discussing asylum negotiation with the prosecution and immigration court. We are fortunate enough to be joined by the lovely Folasade Ajasa.
Hello. Good afternoon, everyone. My name is Folasade Ajasa-Thomas. I'm an associate attorney here at Gehi and Associates, and I'm here to answer your questions. Thank you.
Sure. So full disclosure, our offices were right across from one another. So whenever we had a complicated case, we would yell out the door at one another, and we discuss our cases. Okay.
Yes.
Sade is not only experienced in immigration law, but she also handles bankruptcies, divorce, child custody, and special immigrant juvenile cases. Whereas I'm mostly specialized in immigration and deportation defense, Sade is highly experienced in a wide breadth of legal issues. Okay, so the past two episodes, we discussed asylum generally and how to proceed, where to file, the forms you need, and some issues you may have. Today, I was hoping to talk about negotiation tactics with the prosecutor or Department of Homeland Security, ICE, in immigration court. Sade in the past year or so has had great success with some very difficult and disturbing asylum cases and deportation defense in immigration court by negotiating with Department of Homeland Security. So, Sade, what is prosecutorial discretion?
Thank you, Mr. Greg. It's called PD, and it's referred to as a kind of relief that is issued from the Department of Homeland Security, the councils there. They give this offer to some respondents whose cases seem to be, let me give an example, for example. If, for example, you have a case currently pending in court, and maybe for asylum or for cancellation of removal, and you do not feel confident to go to trial, or you feel like you're not ready to go to trial, or you feel like you don't want to continue in court at that period of time, you could speak to the DHS attorney through your attorneys, and they could grant you a PD whereby your case is either closed temporarily or dismissed permanently. And it's always good for clients also who are having second thoughts or who are having cold feet regarding their case. And it's also very good for clients who also have other reliefs they want to rely on. So for example, you might be in court for asylum, but then you met a US citizen who you're in love with and you want to get married to. We can negotiate for you a PD whereby the court closes the asylum case and you can focus on your reliefs. This is what PD does generally.
Yes, that's a great explanation. So what I generally tell clients is that when you go to trial, you either win or you lose. And when you win, you get a green card, legal permanent residency. And if you lose, you get a removal order, which means you could be deported. So prosecutorial discretion allows for a middle ground where we lower the risk and we can come to a disposition with Department of Homeland Security. As Sade mentioned, a lot of times these asylum claims or any claim in immigration court are pending for years. People end up getting married, life changes. And why would we go to trial for an asylum claim when you're married to a US citizen? There's no reason why you would want to risk that while you have a much more efficient way of adjusting your status to that of a legal permanent resident. There are several different types of prosecutorial discretion. The one that's most commonly used is just outright dismissal. Okay, and that's when you're in removal proceedings and you will ask the court, or excuse me, you won't ask the court, you'll ask the prosecutor, Department of Homeland Security, if they would just dismiss the proceedings against you. These are commonly done in cases where people have been here for a long, long time, and Department of Homeland Security just doesn't want to continue with the removal proceedings. It's also if you have an asylum case or any type of case that's fairly strong, they will offer to dismiss it. It's that, you know, and but the flip side of that is it doesn't give you anything. So if you have a strong asylum case and they offer to dismiss it because they don't want to risk going to trial and losing, your client is left with simply the government agreeing not to deport them. So they won't get a green card, they won't get a work permit. They'll simply be left in the country and the government agrees not to deport them. So both sides use it as a negotiating tactic to prevent what would be unfavorable result at trial. Sade, would you like to talk about administrative closure?
Yes. The second type of PD is called administrative closure. This PD refers to a situation whereby your case is not dismissed from the court. What happened is that your case is temporarily closed. It means that your case is pushed to the back of the docket. It's no longer on the court's calendar at that moment. The effect of this is that with admin closure, it means that you still have an existing case in court. So, for example, if you have an asylum claim in court, you still have your asylum case in court, but it has been closed temporarily. It has been put aside. It has been put away for a while you focus on pursuing other reliefs. The benefit of the admin closure is that once the prosecutor agrees to close your case, you can continue to receive EAD every year with USCIS if you at that moment, and also with the admin closure, since your case is temporarily closed, if you're pursuing other reliefs and they're not successful, you can always go back to court and reopen your case. That's the benefit of an admin closure. But beware that admin closure is not easily granted as compared to dismissal, because with admin closure, the fact that the case remains in court is a good strategy, because it gives a kind of a plan B that should, in case your other reliefs that you're pursuing with USCIS does not work, you don't get your green card or anything, you can always refer back to your case which is existing in court.
Yes, so administrative closure is harder to come by. They really don't like granting it unless there's something pending. For example, if someone's petitioning for you, the court may agree to administratively close your case. I describe it to clients as just a pause. It's basically when the court just pauses everything. And what's great about it is, as Sade just explained, you can keep reapplying for your work permit while your case is administratively closed, okay? So Sade, you had a cancellation of removal case several months ago, and it was very difficult, and you managed to get them to agree through negotiation.
Yes.
To get Department of Homeland Security, ICE, to agree to administrative closure. Can you tell us about how you negotiated for that? How, what came up, and how you were able to succeed?
Yes, thank you very much. This client at that time, he had a cancellation of removal case pending in court and also an asylum case pending. Now, the client is worried because although his case is strong, he did not have, as much evidence as he would like to present. And his confidence going into court for the trial was not as strong as he would like to. Now, in this case, what makes this case so interesting is because this client does not have any other pending relief. Asking the prosecutor for admin closure is very difficult because there was nothing else pending in court. He had no relief. He was an elderly man, and he had no child that could apply for him in that instance. And so when we spoke to the prosecutor, they were offering just dismissal. But this client was worried about a dismissal because this was his only way of getting his papers in this country. All he had at that time was just the cancellation of removal. So he had two options. Either he went on ahead with the trial and risk the trial, hopefully he wins, or admin closure. With the admin closure, his case can be paused while he tries to seek a secondary relief for himself, which is possible. So the prosecutor, when I spoke to him, they were not willing to grant us at first. And we had to sit down and negotiate with them, saying, we know we don't have any relief right now, but our client has been here for a very long time. He has been here for over 20 years. He had no criminal record. His children, although he came in, without the proper papers, which is why his children could not adjust the status for him in the country. That's a different situation. But we tried to explain to them, and luckily, the prosecutor listened to us at the last minute, and he gave my client a PD admin closure. That means that currently, right now, his case is paused. He continues to receive EAD because he's still the head of his family, and he can continue to work with his EAD card. And this was a case whereby we did not even think that it would have been possible, but we're happy that we got a PD admin closure for our clients. And so right now, the pressure of the trial is no longer on him, and he can continue to focus and continue to seek a way to get a separate relief from USCIS in the future.
Yes. So when the case is administratively closed, you just and you want to reopen it, you just file a motion with the court called a motion to recalendar, and they'll set another court date. And it's fairly simple. There's a third kind of PD that we would like to discuss. Sade and I both had success with this, and this is extremely rare to be granted. So I want to toot my own horn a little bit, and Sade's, where it's a stipulation of relief, okay? And Sade had a very upsetting case. It was asylum, and it was quite upsetting, quite gruesome facts. And also, Sade is kind of a force to be reckoned with in court, okay? She's she might seem calm and right now, but in court she's quite a force. So she was able to negotiate for a grant of relief, and that's basically the other side saying, your case is so strong, I don't even want to fight this, I'm going to give it to you. So Sade, could you explain that a little bit?
Yes, thank you, Attorney Greg. This stipulation to relief is a separate kind of stipulation compared to the other two we discussed. This means, like Greg said, yes, we agree. Yes, we believe your client has a claim, even without going to trial. It's not very common. So it is for those who are extremely confident that, listen, this is what I experienced. This is the evidence I can produce. And my case is so serious that even going to a trial is not even necessary. Now, in this case, it's a kind of very sensitive case, so I will not be able to go into so much details, but my client experienced rape from political adversaries, also experienced, was forced to experience female genital mutilation. My client also, during the attack, also lost contact with her children, and even our children also too suffered sexual assault. It was a very, very sensitive case, so much that when we brought the offer for the stipulation to relief to the prosecutors, we said, listen, this is what this person experienced, and there's so much, we have a lot of proof that this happened, and our clients, although she's willing to say her story, but because of the nature of this kind of claim, we believe that we don't even have to go to trial to go over these very sore details with this person. We believe that based on everything she has given to the court in terms of documentations and her testimony, which was written, that the court would grant the asylum. And we brought this offer to the prosecutors. They reviewed our offer and they said they believe, and it's true. So our client was just asked to do a fingerprint to see if she has any criminal records, and the court agreed. So this is, well, like I said, it's always usually very rare because the court would most likely want to go through a trial to determine if anybody is entitled to asylum. But in a situation like this, where your evidence speaks for itself, then the prosecutor can agree to stipulate to relief, and the court also, looking at the facts of the case, would also equally agree, and a trial will be skipped.
Yes, yes. So I also had a case several months ago where I was able to get a grant of stipulation for a VAWA case. So the client got their green card. In Sade's case, it was also very helpful because the client could then bring her daughter, who was also suffering, into the United States from there. Okay, and that's a separate form. Okay, so any other cases you'd like to discuss? Talk about Sade, cancellation of removal, any other times you had PD requests granted?
Yes, it's usually like it depends, sometimes, yeah. Also, important thing is that, okay, so now PD dismissal and admit closure is usually granted easily more to those who do not have any criminal records. But we've had some situation where some clients did add a criminal past, some kind of issue they had in the past that might make it look like they don't have a good moral character. But through our negotiations, we're able to convince the prosecutor that even though these clients had some kind of brush with the law in the past, they are people of good moral character. We could prove this to the prosecutor through our strategies, and it works. And so clients who even have criminal cases are still able to get a PD, even though ordinarily the PD should be granted to those who, in quotes, have good moral character. But our law firm, we have been able to successfully plead and successfully negotiate with the prosecutor team that this client, despite the fact that he had one or two brush with the law in the past, he is somebody who is changed right now and somebody who is currently a person of good moral character, and PD was granted to this client.
Okay. Yeah, most frequently we do PD requests for dismissal when there's something else pending. The firm has countless cases where someone's married to a U.S. citizen, or they have a family member that can petition for them, and they just never did. So somehow they end up in immigration court. Usually we have a lot of cases, surprisingly, people go to Niagara Falls and forget it's in Canada, and then they come back and they have to, they say, where are your papers? And they get put in immigration court. The whole time they've been here, their wife or their child could petition for them. So in cases like that, it's the first thing we ask for. We're able to do adjustment of status through immigration court, but it's a way, it's commonly considered a waste of time and resources. So it's much better to just do it through USCIS. So in those cases, when someone's, doesn't have any issues, they can just adjust their status. We do so. We ask for it to be dismissed. Usually I'll send the prosecutor a copy of an approved petition or a pending petition, because the judges, the courts are overwhelmed, and they're usually happy to get these cases off their docket.
Okay, yes.
So that's another reason.
There are two other cases again, that came up. One of them was this client currently has a pending case with a pending VAWA case with USCIS, and is also in court. Actually, the court case precedes the USCIS pending VAWA case, and we asked for PD request for admin closure to allow USCIS to work on the VAWA case, and it was granted. So that means that currently, right now, our client still has his case in court, but it has been paused, like Attorney Greg said, it has been paused while we decide to see how USCIS works with this VAWA case. Once our client's VAWA case is approved in USCIS level, then we could go back to the case in court, and we could close it, we calendar it and then close it because right now our client already has an approved VAWA and the green card through USCIS. Secondly, also is another case again that came up very recently. Even though this client does not have a relief with USCIS, this client is planning to get married to a US citizen. The prosecutor also agreed to, and they gave us a PD, knowing that he's planning to get married. The reason he hasn't gotten married is because his previous spouse's divorce is still pending and about to be signed. But they also agreed, despite the fact that there is no relief at the moment, but they said, we're going to grant you the PD for your client to get married to a US citizen and to adjust his status. Thank you.
Yeah. So Sade actually brought up an interesting point. So if your case is on pause with administrative closure in court, you can't apply for a green card with USCIS, but you can still be petitioned for or self-petitioning through VAWA. So in some of these cases, we've been fortunate enough to get the case administratively closed in court. We then try our luck with USCIS. And as a backup, if it's denied, we can either leave it administratively closed so we can continue to get a work permit and live here, or reopen it and get a second chance to fight the case in court. So we always have like a backup plan here at Gehi and Associates. We call it double redundancy or belts and suspenders.
Yes.
Where we have, you wear your belt and you have suspenders. And both. We always have a backup plan. And PD is usually, sometimes it's, the first, choice, sometimes it's second choice, sometimes it's third choice. But it's it's little known, but in most all of our cases, it is an option and something we, discuss with the clients. Okay. So where are we now? Any questions you may want to answer?
Yeah, we see some questions in the chat.
Okay. I see some with cancellation of removal. So that could be cancellation of removal can be a whole episode on its own. We can talk for hours about cancellation of removal. Cancellation of removal is sometimes called the 10-year green card. And that's when you've been living here for 10 years or more without being in immigration court and having no legal status. And your removal from the country would result in extreme hardship to US citizen or legal permanent resident family members. Now, in most cancellation of removal cases, it is because you have illegal entry, you entered without inspection, and you have no qualifying relative who can give you a waiver for this. Okay, that's the nutshell. And we can talk about that at length and why. But we still do it quite frequently. We have a lot of cancellation of removal cases, but we prefer if we could get you, if you have a qualifying relative for a waiver, it's a much safer way than going to trial. But like I said, it's mostly with people who have bad entry or entry without inspection, and they have no qualifying relatives, which would be a spouse or parent who could give them a waiver for their entry. Okay. So sorry, I don't know if I answered it. I went on a little bit of a rant.
Oh yes, that's actually a good summary. We can have a separate topic for cancellation in the future.
Yeah,
please continue to join our classes webinar. I see another question. It says, which is easier to prove, asylum or withholding of removal? Just like Attorney Greg said, it depends on the situation. There is no one answer to say, oh, asylum is easier or cancellation is easier. No, it depends on individual circumstances. And we would not know until we speak to you, until we get details of what's going on. There are some people whose asylum claim is very strong. They don't even need to try to go towards, oh, sorry, we're talking of removal. Oh, okay, I thought it was cancellation. Okay, so now when it comes to asylum and withholding, it's much more, it's not easy to prove asylum. unless you can show your facts. So let me give you an example now. You must get asylum. You must be able to prove your asylum, either some kind of religious reasons or political asylum, or you're a member of a social and particular social group, or depending on the situation. If we're able to prove that, and we can prove that, for example, your life was in danger, you had a fear for your life, or a particular government actor was not protecting you, then we can easily prove asylum for you in court. However, we go towards withholding when asylum is very difficult to prove in your case, or if the prosecutor are saying that you do not have enough fear for your life, then we go towards trying to prove withholding. It's not easy, but it's possible. So I believe that it still depends on individual cases. When you come and discuss your case with us, we can tell you if it's possible for us to move on with asylum, or if we have to just hold on to withholding or removal, just to avoid you being removed from the country. Thank you.
So I don't want to get too far off topic, but now because we have Sade here, let's pick on her a little bit. Sade, you're also fairly, you also do a lot of SIJ cases, especially juvenile. Sade and I have had many, cases go back and forth between us, so we work very well together. And sometimes I'll have a case, it'll be an immigrant juvenile who's applying for asylum, and they're either abandoned or abused, and they have an asylum case that may not be that strong. And what I do is I call Sade and I say, please help, take this over for me. Save this child. And she does it, and she'll take the case and convert it from asylum into special juvenile or SIJ.
Yes.
So, could you?
Okay, so we have clients, for example, who are less than 21 years old, and they initially came to us to fight to apply for asylum. We look at their case and we see that if we try to go towards the asylum route for them, it's kind of like 50-50. It's not so strong. We could do it, but it's too equal. Like the chances are too equal. We look at this client case and we speak to them. Where are your parents? Oh, my parents, they've stopped talking to me. They abandoned me. And do you have anybody here who is willing to be your guardian and take care of you? They're like, yes, I have a lost loved uncle who is taking care of me right now, or I have someone who took me in. We have these cases. If you found that kind of situation, we can apply for SIJ for you. With SIJ, we get a guardianship order from family court, whereby the court determines that this person in the US here can cater for you as your guardian, and the court determines that your parents have either neglected, abused you, or abandoned you. Once the court grants that special findings, and we go to immigration, USCIS, and we apply for your SIJ, it is always usually almost granted at almost all times, because they rely on the orders of the family court. So sometimes if you are a child who is not 21 and you and your parents are having so many issues, you can come and speak to us and we could guide you to see if we can file for SIJ for you. With SIJ, it is almost stronger than going to courts to fight asylum in the deportation and proceeding.
Yeah. So for SIJ, you have to be under 21 years of age at the time it's filed with USCIS, correct?
Yes, that's correct. That's very important. So the earlier you come, the better. If you are 20 and you're not 21, you come in, we could go to family courts and apply for you. And also one more thing, we've had clients who were dangerously close to 21, but their case was so strong, and we felt like we have to fight for these clients before we file with USCIS. Our law office was able to negotiate a quick date with family courts for them to review this child's case. We say, oh, he's very close to 21. Please, can you please review his case quickly? And the court did that. The court gave us a close date. The court was able to give the order in time, and we're able to file with USCIS just before the child turned 21. So the earlier, the better for SIJ cases.
Yes, but if you're late, Sade has family court magic. She can get it done. Okay, yes. We prefer you come in early, but I gave you, it was like 2 months before.
Yes, we had 2 months. We've had sometimes. even 1 month, and we've been able to do it.
I had a court hearing and I just saw, I'm like, oh, you're not 21 yet. And
Mhm.
it was a very tough case. He had very little evidence to prove his persecution. I believe he was persecuted. It was,
Mhm.
I believe, there was evidence there, but it would have been very tough at trial.
Trial. Mhm.
I called you and you managed, now it's already sent, it's pending.
Yes.
Back to prosecutorial discretion. For these cases, I would ask for it to be administratively closed while it's with USCIS.
Mhm.
In the event it's not granted, we just go right back to court.
To court. That's always the good thing about PD.
And we could redo his asylum in court.
Mhm.
Is,
Mhm.
is what we would do if for some reason it's not granted.
Yes.
This is an example of how, Gehi and Associates, we all work very well with one another. We all, help each other out, and we'll have an attorney for you here. Okay, we have many great attorneys. We work on cases together, and it's okay. What else can we discuss, Sade?
I'm looking at the questions. Can children under the age of 18 apply for asylum by themselves?
Yeah, that was what we just discussed.
First, yes.
It's much better if you're an abandoned child. I mean, what happens practically is somebody comes in the door with a child, under 21, and they'll say, I've been taking care of this kid. I don't know what to do. He crossed the border, and he can't go back. He fears returning, and we'll assess it. And usually, if you're under 21, SIJ is preferable, and we'll ask that person, are you their guardian? Do you want to be their guardian? But it's very important you get the special findings order from family court, and then you do the application through USCIS.
Yeah.
Okay.
I sent that question. I received asylum. Can I apply for green card or citizenship? Yes. So once you are granted asylum, you are able to apply for your green card 1 year, exactly 1 calendar year from the date you received your asylum approval. And once you do that, you get your green card, and 3 years, I believe, Greg, post your green card, you can apply for your US citizenship. It's very, very possible. That is the basis of asylum. After asylum, you can always adjust to get green card.
Yeah. So once your asylum is granted, you have what's called asylee status.
Mm-hmm.
That's, as Sade said, it's 1 year after the grant, you apply for a green card, just like normal. So the asylum is essentially would you say it's almost like the government is petitioning for you?
For you, yes.
Right. It's like with marriage, it's an I-130, right? So it's a U.S. citizen or legal permanent resident petitioning for you. With like VAWA or the SIJ cases we just discussed, it's you petitioning for yourself.
Mm-hmm.
Asylum, it's similar. The government's petitioning for you.
For you, yes.
Back. So after the petition is granted, then you have to yourself apply for a green card. And if you're granted asylum, you can apply for a green card after a year. And then 5 years after your green card is given to you, you can then apply to be a citizen. Okay. So what else can we talk about? Any more questions?
There's one for you, Attorney Greg. How long does it take to get it? How long does it take to get decision for asylum?
Oh, the first thing I tell people, the first thing I tell my clients is I make no promises when it comes to time. Okay, some cases, and I say this to everyone, and everyone in the office hears me say this several times a day. We've had people come in, families where there's 2 applications being made, and we'll send them out at the exact same time to the exact same USCIS office. One will get back in 4 months, and the other one will take 3 years. We've had we had a case last year of a client crossed the border, had an asylum case. He had a trial date within 4 months. He didn't even have time to get his work permit. Granted asylum. 4 months from the time he crossed the border to the grant of asylum. The firm also has asylum cases that have been going on for over 10 years.
Yes.
Okay. It depends on the case. It depends on what's going on, how long you've been in the country. But it's a wide variety of time. Okay. So anything else? So I think next week we can talk about waivers, which is, I want to say it's one of the most important tools we use as immigration attorneys. Most of our clients are people that have been here for a while and been living in the United States for a while and either had no status or lost their legal status. And a waiver is basically, it's basically an I'm sorry. You made a mistake, either how you entered the country, you violated the terms of your visa, there's some criminal issues, maybe you committed a crime. And a lot of the time we ask, we go to, the government and we say, hey, they made a mistake, let's fix it. And it's a very important tool we use. Okay. So just so everyone knows, past results do not guarantee future results. This talk show or whatever we podcast is not intended for legal advice, is simply educational and general knowledge. It's also considered an attorney advertisement. So please consult an attorney before acting. And this is not legal advice. We have 3 offices in Queens and 1 in Mumbai, India, and soon another office to open up in Bangalore, India. You can reach me in Ozone Park. You can reach Sade in Jackson Heights. She has the nicest office. In Jackson Heights, and we have another office in Jamaica. Okay, the phone numbers are listed right here. If you'd like the addresses, you can look us up on Google. And we have 3 offices in the United States, 1 in Mumbai and 1 soon to be opening up in Bangalore. Okay, so thank you for watching today, and we'll see you next week. And special thank you to Sade.
It was a pleasure.
Offered to come here last minute notice and save the day.
Thank you very much. I'm so glad to have this opportunity with you, Mr. Gregory. Thank you very much. And if you all have any questions, like you said, please do not fail to call. It's a free consultation. You could call and we could answer your questions and we could help you and let you know how strong your case is. Thank you for listening.
Okay.